Whakamana I te tiriti o Waitangi tēnā koutou. I te koreina, I ngā hoa mai e nuwana nei tēnā koutou. E ngā mana e ngā reo, e ngā hauepa e pitaki tēnei ata, tēnā koutou, tēnā tātou katoa. May Police Tribunal Council's name is Nathan. With me is Ms. Roughton. These are the opening submissions for the Y2610 claimants. This document is document 3.3.102. The claimants to comprise the Y2610 claim are set out at page 2 of the opening submissions. I won't go through those. So the application was filed on the 28th of February 2017. And in support, there was a brief of evidence from Mr. Peter Wairata Warren, also known as Wairata Te OneOne. Mr. Te OneOne is here present today, sir. This brief of evidence was document A1 on the Y2662R01. On the 28th of July, the Deputy Chairperson granted urgency to this claim. Since the granting of urgency, there's been the filing of the brief of evidence of Mr. Topi Jim Wikotu. Mr. Wikotu is seated here, sir, present, but was unable to present his evidence today, Your Honour, members of the panel, because he is not well at this present point in time. Nevertheless, he is present. So firstly, the claimants wish to state their support for the other urgent claims that have been brought before this tribunal. They focus in particular on issue 6 of the tribunal statement of issues, which talks about the prejudice resulting from mandate approval. The evidence and submissions applied to this tribunal by the claimants are about asserting that the Crown's approval of the deed of mandate prejudices them because, as stated by the Waitangi Tribunal in the recent Ngāhui Mandate Inquiry Report, and I quote, the intended settlement timeframe is such that Hapu will very likely lose the opportunity to seek binding recommendations from the Tribunal in circumstances where the Crown has not asked the Hapu concerned for their consent to that outcome. So this argument is based on the prevalence, the availability of binding recommendations. That tribunal, the Ngāpuhi Mandate Tribunal, found that the loss of the right to seek binding recommendations breached the principles of utility. And in doing so, it's very important to note that in order to make that particular finding, that tribunal was prepared to assess future prejudice. That's a quote, future prejudice, arising from mandate approval by the Crown. It did not matter that the prejudice complained of had not yet occurred. The mere prospect of prejudice arising was enough. Moreover, the prospect of binding recommendations in relation to any historical treaty claims by claimants who do not consent now means that the settlement of any such claims by way of direct negotiations with the Crown can never be treaty compliant. Accordingly, the key submission we make is that direct negotiations that lack the consent of all of the claimants involved in circumstances where state assets can be applied for by way of the resumption provisions are now a thing of the past. Direct negotiations of that nature cannot fly. According to the Supreme Court in Haronga 2011, and I quote, if the opportunity to obtain restoration is lost, this is restoration by way of use of the resumption provisions, if that's lost, the claimant will suffer significant and irreversible prejudice through the proposed settlement. Hence, we contend that the opportunity to exercise the right of resumption is fundamental enough to offset a treaty settlement. Members of the panel, that's the thesis. In turning to the evidence of Mr. Wikotu, he expressed a desire to have his treaty grievances heard by the tribunal so that in the event that his claims are held to be well-founded, he could then make application for resumption. He cannot do that unless there's a hearing. So there's some evidence in Mr. Wikotu's brief about Crown Forest lands, referred to here as CFLs. Your Honour, it may be that that evidence is incorrect. We've sought to check the availability of CFLs to claimants in this inquiry district and to submit in that regard, Your Honour. But as it stands, Mr. Wikotu's evidence is that there are CFLs available for resumption. If that's the case, then he argues they should be amenable to return to his iwi Mpogore.
Mr. Nathan, can I just clarify that, just while we're on the issue? So you're saying that there may be an error in the evidence file at this point, and you're seeking leave to investigate further. Is that what your submission is?
Yes, sir, essentially, yes.
Right. Thank you. Carry on.
Can I say though, even if there are no CFLs available for resumption, that is not fatal to the argument being put, because there are other state assets clearly within the inquiry district, and these are relied on as well. For instance, Mr. Wikotu referred to a series of Crown properties, and that they should be amenable to return to him. In particular, he focuses on the property at 153 Duke Street in Portuguese. I visited there yesterday, sir. It's a large house, and for years, well, it was designated when it was built as a community services centre. So it has all sorts of spaces and rooms and provision for the for community servicing. And Mr. Wikotu has tenanted that property for 11 years or more. And has been associated with that property for much longer than that. It's a state-owned asset. It's amenable to resumption, and it's our submission that Mr. Wikotu should be the Māori in accordance with Section 8A, 282, to whom the property is returned. However, in the event that direct negotiations between the Trust, WPSCT and the Crown are allowed to continue, the opportunity for Mr. Wikotu to seek the resumption of all or some of the aforementioned state-owned assets will dissipate altogether. And that's prejudice. The submissions being made hinge on the right that Mr. Wikotu and the other claimants have to their historical treaty claims being heard by the Waitangi Tribunal. This is another component to this argument. The right to be heard is enshrined in Section 6 of the Treaty of Waitangi Act, and the Supreme Court in Haronga confirmed that there is a mandatory obligation on the Tribunal to inquire into the claimant's claims. The Chief Judge of the Waitangi Tribunal heard that finding and applied it in the National Freshwater and Geothermal Resources report by way of the Freshwater Tribunal by stating as follows in emphatic terms, and I quote, "The Tribunal should not put too much weight on the existing dialogue between the Crown and iwi leaders. Māori have a right under the Bill of Rights to be heard." And there His Honour is talking about the Bill of Rights as a source of the right to be heard. And according to the Supreme Court decisions in Haronga, so His Honour Chief Judge Isaac is also applying the Haronga finding. He went on to state Māori claimants have a right to be heard even when others are in negotiation. Denial of a hearing to prove a right is denial of a right. So those two venerable forums have espoused in this way, and we pick up on that. Claimants are entitled to a hearing, even though the WPSCT may be embarking on direct negotiations with the Crown. This is now well established. Furthermore, the Supreme Court in Haronga looked at the meaning of inquiry and was careful to state that it's not just the hearing of evidence or even the filing of evidence, but it's those activities and importantly, it culminates in with the issuance of a report by the tribunal. That is an inquiry. And so, this is what the claimants would seek when they ask for a hearing, when they ask for an inquiry. This is all the way through to a tribunal report. We contend that the process of determining whether or not the claimant's claims are well-founded must involve a report. For there to be a report, there must be a hearing of treaty claims. A simple formula. Returning to the importance of the resumption provisions, and the courts have espoused in this regard. Both Section 8A and Section 8HB allow for the sale of state-owned assets, but in a way where claimants' property rights can be preserved. These sections were enacted to protect treaty claimants with well-founded claims in the event that the Crown did not comply with tribunal recommendations. So, and as you're aware, sir, they've been deemed to be adjudicatory in their function. In other words, binding and perhaps even likened to the making of an order on the Crown. And all of this was devised purposefully during the late 1980s when the Crown was looking to sell more land and avoid those lands being made subject to settlement and including Crown forest lands. The legislature moved to protect such interests. And that is all the claimants seek to do with their proposed application of those provisions. At paragraph 11, the lead provided by the Supreme Court was taken up by the Waitangi Tribunal in the recent Ngāpuhi Mandate inquiry. There, the importance of preserving the claimant's right to apply for resumption in circumstances where a settlement would have otherwise curtailed that opportunity was also recognised. It was recognised in the following way, and I quote, "By recognising the mandate of the Tūhoro Nuku IMA to negotiate the settlement of all Ngāpuhi historical claims, the Crown has effectively removed the capacity for Hapu to seek binding recommendations from the Waitangi Tribunal. And as a result of that finding, or that thinking, a particular finding was made by that tribunal in this respect. And then a finding in relation to prejudice was also made by that tribunal, prejudice arising should there be no opportunity to seek binding recommendations." It is noteworthy that it is, and I quote, "the opportunity to exercise the right to resumption" that was upheld. Our purpose here today in Council's estimation is not to argue the substance of any application for resumption. It is to argue that there should be opportunity. If deed of mandate approval is allowed to proceed, that enshrined opportunity will be lost, and the Council's submission makes illegal. In conclusion, we note that the Ngāpuhi Mandate Tribunal paused the direct negotiations there on the basis that, inter alia, successful Northland Treaty claimants would lose any opportunity to have state assets transferred to them. However, after pausing, settlement negotiations were allowed to continue alongside the hearing of Ngāpuhi's historical treaty claims. The claimants seek the same outcome here. They ask for a pause so that an expedited tribunal hearing can be initiated. Once the hearings are underway, and in the event that a mandated settlement entity is formed, a suitable one, settlement negotiations